Hey, this is Jack Ryan, and welcome to another session of the Legal and Liability Risk Management Institute's virtual training. I want to talk to you today about neck restraints and the various types of neck restraints, how the courts look at them, how the medical field looks at them, and kind of cover all of the issues related to neck restraints. Obviously, we had a recent event up in Minneapolis where an officer kneeled on Mr. George Floyd's neck, one side of it, for a period of time, more than 8 minutes. And that has brought neck restraints to a forefront. In fact, the United States House of Representatives introduced a bill that would ban both carotid restraints and chokeholds in the future for law enforcement. Now, bear in mind that generally Congress does not dictate law enforcement practices to local law enforcement, so they would do so based on what we call the purse strings. In other words, they could cut off funding to any agency that did not adopt the banning of chokeholds or carotid restraints. So things like the Byrne Grant, things like all the federal funding that law enforcement receives as a result. I think at the outset we ought to talk about 2 or 3 different things. First, let's identify the different types of neck restraints in turn, so we're kind of on the same page with how we start talking. A chokehold is essentially, and the courts, a lot of the courts have even looked at it this way, a chokehold is essentially a respiratory hold. In other words, it's a hold where an officer uses an armbar technique, for example, and puts their forearm across the subject's throat and cuts off the oxygen that the person is able to take in. So that's a chokehold. It's respiratory based. I will tell you that when you look at some of the old cases, even when you look at some of the old training, even quite frankly, when I first became a police officer, we were trained even to use our flashlight or our nightstick and place it across somebody's throat in order to stop them from fighting when you were in a real significant level of resistance. So again, that's a respiratory hold. We want to distinguish that from a carotid hold, and the carotid hold, obviously, just by its terms, is a vascular hold. In other words, it's to cut off blood to the brain. You do that by putting pressure on generally both sides of the neck. It's kind of interesting that Minneapolis, actually in their policy, and we'll take a look at that a little bit because I think it's something that we should consider. There may be other agencies that have that policy, but it's a situation where we generally put pressure on both sides of the neck, generally with our arms, and in Minneapolis's case, they actually have that you can do this with your leg as well, and it calls for compression on one side of the neck. You can do both, but it also contemplates that you can do one side of the neck. So again, we do see the carotid restraint different. I think it should be also mentioned that all carotid restraints are not necessarily the same. In fact, in many years ago in the Kansas City, Missouri Police Department, a man by the name of Jim Lindell actually started training the lateral vascular neck restraint, the LVNR. And LVNR is now trademarked, so it's a registered trademark. So LVNR is not always what the courts are talking about when they talk about a carotid restraint. Certainly the LVNR is a carotid restraint, but it's not necessarily just a carotid restraint. The LVNR actually contemplates 3 different levels, so 3 different levels of pressure. And when you start researching the LVNR and you start looking at the National Law Enforcement Training Center, which is a nonprofit that was formed in Kansas City, where they do a lot of training on the LVNR system. When you start looking at that, they talk about these different levels, and they mention the fact that most of the time, in fact, somewhere around 10% or less, most of the time the person complies or comes into compliance before they're ever put out unconscious by this restraint. So again, they talk about 3 different levels of pressure. The pressure is changed by the manner in which you're delivering the hold and the angle of your arm at the time. So again, there's way to do that. So we've got lateral vascular neck restraint, which is a trained system that achieves compliance most of the time, and according to the National Law Enforcement Training Center, without ever putting the person unconscious. Then we have carotid restraints overall, and then we have the chokehold. Again, chokehold being oxygen cutoff, carotid restraint being blood flow cutoff, and then we have the lateral vascular neck restraint, which is really a three-level system. I will tell you that as I look at cases, in what I do today, I often get cases where officers will describe what they did, sometimes in terms of mixed martial arts moves, and other different types of moves. I've had cases where officers have told their supervisor that they did, quote, a rear naked chokehold on the subject, or things of that nature. And so we do see a lot of that. I think there's also some things that we have to recognize, particularly when it comes to these types of techniques. These are all perishable skills. When we train officers to do highly technical physical skills, they are perishable. So it's not a one and done. This is, again, the lateral vascular neck restraint points this out in all of their literature. You got to retrain this on a regular basis in order to be proficient at it. And if you're not proficient at it, then you shouldn't be doing it. So agencies that adopt this have to make sure that the training is consistently done. Hey, I want to talk about science and medical findings with respect to particularly carotid holes, because I don't find much in the literature related to anybody trying to refute the fact that if you put a chokehold on the front of somebody's neck, that you can cause serious bodily harm or death by cutting their oxygen off for a lengthy period of time. Also, we see cases where the hyoid bone, which is in the front of the neck or in the throat area, can be fractured during these kinds of tactics if they're used. As a result, and we'll get into some policy issues, but most agencies either ban the chokehold outright or they limit any use of the chokehold to a deadly force situation. The situation with carotid holes is a little bit different. There is some disagreement, and as I look at a lot of the law enforcement literature, I happen to pull some stuff the other day, and one that I came up with was an article in the Arizona Troopers Association. It had written something for their membership that is on the internet. And, it talked about a study that was done that refutes the idea that carotid holes are dangerous. It's hedged a little bit, but the article cites to a study where they did numerous testing of individuals without any significant injury. The researchers concluded that this was a safe and effective means. Now, the researchers, even in the article for the Arizona Troopers, said, look, if you had people that were unhealthy or elderly or something like that, those people weren't part of our study. The study did say, though, that people that are on drugs, people that were impaired, may lose consciousness even faster, and them being the people that may need this tactic to be deployed in more settings. One of the things we should always recognize about these settings is that a couple of things. One, when we're doing research like this, we can't duplicate certain things. So, for example, an officer who becomes part of one of these research projects, a college student who becomes part of these research projects, one, they're healthy individuals. Two, they know something that the person on the street doesn't know. They know that they can tap out at any time. They know that eventually they're going to be released. So there's certain things. They're not necessarily in the state of panic that somebody being arrested is in, or they're not in the state of actually fighting like somebody, an agitator like somebody being arrested is. And so that may somehow change the dynamic. We're also not using individuals that are drunk, high, and other things mentally impaired, what have you, as part of our study sample. So that may change things as well, and those are variables that we cannot account for. I will tell you that Dr. Bill Smark, who's the surgeon for the Louisville Police Department, the police surgeon, I've seen some materials that he has presented where he talks about the fact that a carotid restraint can actually cause significant injuries. People, after they have the carotid restraint, and he cites to examples in jiu-jitsu, he cites to examples in law enforcement training, where after they've had this carotid restraint put on them, maybe not immediately, but even sometimes hours later, they have issues with their carotid artery that cause them to have a stroke. So again, it can, according to Dr. Smock, lead to some serious injury in these cases. So again, there's this kind of disagreement. As I've said in other areas, like in the asphyxia areas where there's some disagreement, excited delirium where there's some disagreement, law enforcement's got to kind of pull themselves out of those disagreements and then talk about what tactics are reasonable and when they're reasonable. And we get that perspective many times from the court decisions, which we're going to get to. But first, we're going to turn to a couple of policy provisions, because I think it is important to look at policy. Prior to the death of George Floyd, the Minneapolis Police Department had a policy on use of neck restraints and chokeholds. They defined a chokehold as a deadly force option and mentioned that it's direct pressure on the person's trachea or airway, the front of the neck, that blocks or obstructs the airway. So therefore, it's an oxygen or respiratory type hold. Then the agency defined neck restraint, and they defined two types, both of which are non-deadly force options. Again, Minneapolis defines it as compressing one or both sides of a person's neck with either an arm or a leg without applying direct pressure to the trachea or the front of the neck. And then, they do indicate that only sworn employees who have received training from the training unit are authorized to use neck restraints. Minneapolis Police Department authorized two types, both the conscious and unconscious neck restraint. The conscious neck restraint is when the subject placed in a neck restraint with intent to control and not to render the subject unconscious by only applying light to moderate pressure. Unconscious neck restraint being the subject placed in a neck restraint with the intention of rendering the person unconscious by applying adequate pressure. The Minneapolis policy also instructs officers on when these types of neck restraints can be used. As I mentioned before, chokehold can only use where deadly force would be justified. The conscious neck restraint can be used against a subject who's actively resisting, so any subject who is actively resisting. The unconscious neck restraint, a little more limited, shall only be used in the following circumstances: on a subject who's exhibiting active aggression, or for life-saving purposes, or on a subject who is exhibiting active resistance in order to gain control of the subject, and if lesser attempts at control have been or would likely be ineffective. Neck restraints shall not be used against subjects who are passively resisting, as defined by the Minneapolis policy. The policy also provides for some aftercare guidelines. After a neck restraint or chokehold has been used on a subject, sworn Minneapolis Police Department employees shall keep them under close supervision until they are released to medical or other law enforcement personnel, and officers who have used a neck restraint or chokehold shall inform individuals accepting custody of the subject that the technique was used on the subject. So again, there's no mandatory requirement of medical care. There's no mention of rendering aid if the person is showing signs of physical distress. However, they do talk about releasing them to medical or other law enforcement personnel and making sure that anybody they're released to is aware that the person, the neck restraint or chokehold was used on the subject. To take a look at the Las Vegas Metropolitan Police Department's policy on lateral vascular neck restraints. Notice that they have actually used the system that came out of Kansas City, the registered trademark. Recently, Las Vegas Metro changed this force option and put it at an intermediate level, no matter what, whether it was at level 1, level 2, or level 3, which we'll talk about. The policy describes, as we have done, that it's a control technique where you use pressure on the sides of the neck to restrict blood flow to the brain, causing the subject to pass out. Las Vegas does recognize 3 different levels, so I want to point that out. No officer can use the LVNR without completing the 12-hour certification course provided in the academy, and that has to be provided by LVNR instructors, certified instructors only. Additionally, all officers get regular training on this continued training. Remember, we talked a little bit about muscle memory control, and we talked about the perishable skills issue. This being a perishable skill, really important that you provide training. The LVNR is a defensive tactic to quickly and safely stop aggravated aggressive resistance. The LVNR will not be used on subjects who have been exposed to OC spray or who are already experiencing difficulty breathing, recognizing that this may exacerbate the issue. It should be noted, Las Vegas does have a prohibition against chokeholds. They don't call it that, but they note that officers will not use any armbar techniques that involves a neck restraint, recognizing the fact that the armbar technique was something that was used in the form of a chokehold on other occasions. They do list some tactical considerations. When applying the LVNR, only amount of force necessary to bring the subject under control will be used. Again, this goes to the levels, right? 3 different levels. The first 2 unlikely to cause the person to actually pass out, as indicated. And in most cases, I think if we look at the National Law Enforcement Training Center's statistics, they say that only in 10% of the cases do you put the maximal level of force on the carotid artery such that the person actually passes out. Las Vegas really reminds officers that when the subject's brought under control, the LVNR will be relaxed. One of the things, and I've looked at the training on this a number of times, and remember that the training would indicate that a person, if the full pressure is put on the person, that they should pass out within 4 to 7 seconds, somewhere between 5 seconds and 20 seconds to recover and come awake again. Some additional considerations. Unlike Minneapolis, Las Vegas Metro requires medical attention on all uses of the lateral vascular neck restraint or any incident where a subject is injured and complains of injury. So it goes beyond the LVNR. Also requires a supervisor to be notified as well. In much the same way as the Minneapolis policy, officers have to inform detention personnel that the lateral vascular neck restraint was applied on the subject, and to ensure that they're properly screened by the detention facility medical staff. And as in most use of force instances, obviously Las Vegas Metro, like other agencies around the country, require officers to report on a use of force report form. They use IA Pro, so it's a blue team report, that the LVNR has been used upon a subject. We're almost 20 minutes into this training, and you might be asking yourself, you're looking at this and you're saying, Jack, my agency doesn't do the lateral vascular neck restraint. My agency doesn't do carotid holds. My agency doesn't do choke holds, and we're not allowed to do that kind of stuff. And you might be asking yourself, well, gee, why are we doing this? And as I travel the country, particularly in classroom-led training, one of the things I ask officers from time to time is, even though the agency doesn't do carotid restraints, choke holds, I ask them how many have seen an officer grab somebody by the throat. I ask them how many times they've seen an officer with their arm around somebody's throat. How many times they've either themselves or seen an officer with a struggling individual try to put the subject in what we would commonly refer to as a headlock or some other type of upper body control and have it devolve into something that looks more like a chokehold. So I think, that's one of the things that we have to recognize is, yeah, while there's names that we put on certain things, there's a lot of things that we do. in the course of dealing with a resistant subject that we have to use a degree of caution to make sure it doesn't devolve into what certainly others would say is a chokehold, certainly something that maybe looks like a chokehold. So again, we use a lot of different upper body controls, including a headlock or something like that, that could devolve into something that could impact somebody's breathing or blood flow to the brain, even though we don't train on chokeholds other than in the deadly force case or lateral vascular neck restraint or carotid restraints, what have you. So I think this is really important that we have a great understanding of all of this, and then as we move forward and we start to look at the cases, it gives us a better idea of how we should respond in these events. I think before we get too far along, it is worth mentioning that any use of force by law enforcement when considered under Fourth Amendment analysis and even under most state law is judged by the standards that come from Graham versus Connor, which was a 1989 U.S. Supreme Court case that has basically withstood the test of time. In Graham, the court said, hey, look, you've got to consider three things to determine if an officer's use of force is objectively reasonable. How serious is the offense the officer considers at the time the force was used? So an important piece, it's not necessarily the offense that initiated the contact. So for example, you might stop somebody for a traffic violation, but if in the course of the encounter they pull a gun on you, then it would be the pulling of the gun. That would be the offense, not the traffic infraction. Whether or not the subject poses an immediate physical threat to the officer or anybody else present, and when we look at that, we really have to consider what that level of threat is. Because we have all different kinds of threats. We could have a threat with a weapon, which is at the high end, versus a verbal threat at the low end. So again, does the person pose an immediate threat to the officer or someone else present that the officer is trying to protect? And then finally, whether the subject is actively resisting or attempting to evade arrest by flight. I think it's also important to put on the table that deadly force has its own definition that has been adopted across the board by our federal courts. And deadly force is defined as that amount of force which creates, quote, a substantial likelihood of serious bodily harm or death. So there are cases, for example, involving canines. The dog bites someone and the person dies as a result, and plaintiff argues that the officer used deadly force. The courts have pretty universally, not unilaterally, but universally have taken the position that that's not deadly force because dogs are used to bite and hold on a lot of suspects. Most of them don't die, so the use of a canine does not create, quote, a substantial likelihood of serious bodily harm or death. We have to apply these definitions to the situation with the neck restraints as well. The United States Supreme Court has only considered carotid restraints or chokeholds in a single case, and it's not your typical use of force case. It was actually a case where a man by the name of Lyons was actually seeking an injunction to stop the City of Los Angeles Police Department from ever using a chokehold or a carotid restraint again. His situation was he was stopped for a traffic violation of some sort. His allegation was that during the course of that event, 4 officers took control of him and used either a carotid or chokehold on him, carotid restraint or chokehold. And so he brought a lawsuit, in part of that lawsuit, seeking a permanent injunction, as I said, to stop Los Angeles from using this tactic anymore. And the lower courts had at least partially granted his injunction, his preliminary injunction. So it goes up to the United States Supreme Court. And one of the things when somebody seeks an injunction, they have to show that they're likely to suffer harm in the future from whatever it is they're trying to enjoin. And really that's what this case came down to. The court did mention a couple of things. One, in the time span between the initiation of this lawsuit and the time it got to the Supreme Court, Los Angeles had 5 more deaths related to chokeholds. As a result, the city had essentially prohibited chokeholds, and they had put a moratorium on the carotid restraint for 6 months, other than in deadly force cases. So, there was some resolution already, if you will, to these events. Bottom line is, the court refused to issue the injunction and enjoin the city of Los Angeles from getting rid of these tactics. And the court took the position that Mr. Lyons didn't have what they call standing. In other words, he couldn't show that he was likely to suffer from a chokehold or a carotid restraint at some point in the future by the City of Los Angeles Police Department. So because he couldn't establish that he was likely to suffer future harm, he didn't have the standing, if you will, or the position, if you will, to get an injunction against the City of Los Angeles. The Valenzuela case is a case where a woman called the police and reported that she had been followed home by a man who was acting very strangely, had had some conversation with her, and law enforcement initially located the man, Mr. Valenzuela, in a laundromat. We're going to look at the video that was released by authorities relative to the officer's actions and Mr. Valenzuela's actions in this case.
Howdy. You all right?
Yeah, I'm good.
Or you
wash my clothes.
just break a pipe or something? Hey, stop. Stop. Just stop, okay?
Yeah.
Put your hands behind your back. Put your hands behind your back. Stop. Stop. Stop.
Stop it. What are you doing? I'm bleeding.
Let's just take him to the ground. Get on the ground.
Get on the ground, all right? I didn't do anything. Okay, you need to get on the ground.
Get on the ground. Get on the ground. Stop. Relax your arm. Stop fighting us. Relax your arm and stop fighting us. Relax your arm. Stop fighting us.
He's out. Is he out?
No, he's not. Stop fighting us! You got him on the carotid? Stop fighting us! Adam, he is great in
Season? Stop! Stop fighting! Get on your stomach!
Stop here, please.
Okay, let go of your arms.
If you roll over and we'll get on top of him.
I can't breathe.
Yep.
I can't breathe. What? Please do it. Face the ground. Ryan, for what? Help me. You're under arrest. Stop, please. Stop.
Now you can get there.
Stop. Please.
Stop fighting us.
No. Stop. How did you shit, you dude?
You need to stop fighting.
Stop it.
Put your hands behind your back.
Stop it, because you know. I need to shut up. I didn't stop so fucked up. Stop,
Put your hands
please.
behind your back.
Stop. Please. Oh, please. Stop it. We're not your stuff. We're not your stuff. Stop it! Stop! Stop! Stop it! Stop it! Stop it! Ow! Stop it on the ground! Get on the ground! Stop it! Stop it! Ow! Ow! Stop it! Stop it! Stop! Get on the ground! No! No! Help me! Ow! Ow! Get on the ground! Please stop! Get on the ground! Stop, please! Get on the ground! Get on the ground! Get on the fucking ground! Oh, stop, please! Stop, please! Get on the ground! We're near the 7-Eleven. Northeast corner. Stop it! Stop it! Help me! Help! 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 Get in your stomach! We got cops! Help me! Help me! Help me! Help me! Help me! Stop it! Help! No. Stop resisting. Hold that choke. Hold that choke. Get a good put that inside that bicep. Stop resisting. Hold it. Stop resisting. Hold it. Just put him out. Put him out. Stop resisting. Stop resisting. Hold it. Hold it. Push it in tight. You got it good? Hold it. Hold it, he's still fighting. Stop resisting! Get on the stomach if you can. Try to roll the stomach. There you go. Okay. Hold it in there. Do handcuffs on him. Give me yours. So tell me if he goes out so that you can stop. Okay. So underneath, lift up your hips. Lift up your hips here. Grab that other cuff. Got it? Yeah. Okay, let me see. Okay, is he out? Let him breathe. Let's get that arm in there. Are you letting him breathe? Is he?
Yeah, I don't have the whole thing.
Okay, good. Okay, let's get him to the side. Everybody off because he's out.
I'm going to do the seat.
Okay, let's get him on his side.
He's going to wake up just like that.
Get him on his side. Can you get him on his side or no?
Have him come in.
All right. He's purple right now, so I want to make sure he's breathing. Let's get him on his side. Go ahead. Okay, let's start. Let's look at
You want to get a chest
CPR. Get an ambu bag.
bag? We got a pulse?
No, I don't know. Let's check ABCs. Let's go. Airway. See what he's doing.
Somebody got another glove? He's breathing.
Where I'm breathing around.
That's there. Sam 266. Right away. No safety. All right, let's start ABCs. Let's go.
He's gurgling.
Okay. Let's get him on his side.
Not finding a pulse.
Keep this leg right here.
No, there he is.
There you go. Okay.
Hey, in this case, we can use this case, the video from it that was released from authorities, and we can take and then look at how the court viewed the case on what we call summary judgment and qualified immunity. And then we can even see in a case like this what a jury determined at the end of the day, because all of those results are now in. I do want to mention that summary judgment and qualified immunity is a method by which officers seek to have the case dismissed before it ever gets to trial. And essentially it works this way, is that an officer will say, look, even if you believe the plaintiff's version of events, so the other side's version, nothing unconstitutional was done by the officers. If the court agrees with that, that's on the merits of what the officer did and the merits how they react with the Constitution. If the court agrees that there's nothing unconstitutional, even under the plaintiff's version of events, then the court grants summary judgment. Sometimes a court won't even address that question. Sometimes they'll determine that the officer's actions were unconstitutional. And in those cases, officers get the opportunity to also argue that even if their actions were unconstitutional, the law wasn't clearly established. In other words, there wasn't another case like this, so this officer shouldn't be held responsible since the officer wasn't on notice. Most of the cases we talk about, these written decisions, are on summary judgment and qualified immunity. So I think it's important to have a sense of what that means. At any rate, in this case, the court looked at several issues, and the court really went to great lengths to detail what you've already watched. The first confrontation with Mr. Valenzuela, who was putting his clothes in the washing machine when the officers approached. What you can't see in the video is one of the officers saw a screwdriver in the bag that he had his clothing in and became somewhat concerned about that. You also hear the officer ask about glass breaking. The officers thought that he had broken a glass pipe when they were on their way in to the laundromat. So those are a couple of issues that really aren't explained by the video. What you do see is a disagreement, and this is something we've talked about already, but now we're going to put it into some practical application. The officer in this case says that he did a carotid restraint and not an air chokehold. Department policy, air chokehold is only for deadly force situations, and obviously the carotid restraint is something different from that. So the officer is saying that this is the carotid restraint. The plaintiffs are saying that no, this was an air chokehold, and there's points where Mr. Valenzuela, particularly in the laundromat, is saying that he can't breathe, and then there's points in the second part of the video, which happens to occur in the parking lot of the 7-Eleven, where the court notes that in the video you can hear Mr. Valenzuela having trouble breathing. And in addition to that, you hear the officers talk about him turning purple, and if you watch the video closely, you can even see him turning purple. But I think that's it's important to note that these cases, carotid restraint, different from the chokehold, from the standpoint of what type of tactic it is. In this case, the officer says, that he only did that carotid restraint in the 7-Eleven parking lot for a short period of time, and that actually what you see that looks like a neck restraint is actually him trying to move into position to accomplish it. The court notes that in fact it's 60 seconds or almost 60 seconds. The court found two things. The first part of this is a little bit unusual, but they found that a jury could find that there was a violation of due process because the officer's actions shocked the conscience. Usually we don't see that in these kind of use of force cases. That use of force is judged strictly by the Fourth Amendment, but the court does go on to point out that a jury could also find that this force was excessive under the Fourth Amendment and unreasonable. Another thing that happens at the end of the video or toward the end of the video in that 7-Eleven parking lot, we see that a supervisor pulls up. His camera comes up on the video, and we hear the supervisor giving instructions, some of which are to maintain the hold. The supervisor is there for a period of time while the hold is maintained. And the court says a jury can find that the supervisor failed in his supervisory position or capacity to make sure that the hold was being done properly and to stop the hold from being done. So it's not a strict duty to intervene situation or bystander liability situation. What it is instead, it's the supervisory liability for failing to stop your officer from doing something that ultimately may be unreasonable. So in this case, the officers have to go to trial because the court denied summary judgment and qualified immunity. So the trial does in fact take place, and I'll tell you that the jury ended up awarding the family of Mr. Valenzuela, who died in the hospital some period of time, days later after this event. They ended up awarding the family over $13 million in this case. So that was the outcome of the Valenzuela case. Hey, McCoy versus Meyer is a case out of the United States Court of Appeals for the 10th Circuit and provides some good examples of the way the court will apply the grand factors to carotid restraint, and we'll look at, issues of before the person is restrained and after the person is restrained, and the use of force maybe continues. So let me tell you a little bit about the case. So this is a case where you're dealing with a really bad subject. I mean, he's holding his sister and his child hostage in a motel room because he doesn't want to turn the child over to the child's mother. When the police get called to the Budget Inn and make entry into the room, he's alternately pointing the gun at his sister. At some point, he's actually pointing his gun at the police. At some point, the police are able to get the sister and the baby or the child out of the room, at which point an officer tries to tackle, basically, Mr. McCoy. The officer at some point believes McCoy is trying to grab his gun. A second officer puts McCoy in a carotid restraint for 5 to 10 seconds. McCoy loses consciousness, and the officer is able to zip tie him and prone him out on the ground. Now, that's use of force number one. Use of force number two comes after he's restrained, and he alleges, and remember, it's always plaintiff's story when we're looking at summary judgment and qualified immunity that the court has to adopt when they're considering dismissing the case. So Mr. McCoy's story is that after he's zip tied and prone on the ground, that at that point officers strike him 10 more times, and an officer puts him back into the carotid restraint for another, I think, 10 seconds. So that's the allegation. So the court breaks this down into Graham as two separate uses of force. And they look at how serious is the offense. So let's take it from the beginning, because this prong, it's the same throughout. The court says, hey, this is a dangerous individual. He's got a gun. He's committing a serious offense. He's pointing the gun at his sister. He's pointing the gun at the police. He's basically holding hostages. So the seriousness of offense weighs certainly in favor of law enforcement and the use of force. They look at physical threat and they say, hey, physical threat and active resistance in the first use of force is present because, this is a guy that had a gun. This is a guy that was holding hostages. Now the officers are trying to put him into custody and restrain him, and he's at least trying to grab at the officers and grab at the officer's gun potentially. So the court says, hey, with respect to that use of force, certainly no reasonable jury could find that the officers acted contrary to the Constitution. But when they looked at the second use of force, after he's restrained, the court said, hey, seriousness of offense is still there, but now what is the physical threat? See, because now the physical threat is diminished by the fact that he is restrained in zip ties. There's at least 5 officers in the room. He's prone on the ground. So that's number one. And so no great physical threat at that point, even though you still have seriousness of offense. And you don't have the active resistance or attempting to evade arrest by flight. So it provides a good example that, sometimes courts will find that the carotid restraint is a reasonable use of force, but the court will scrutinize it a little more when we talk about the person being restrained, because that diminishes physical threat and actually diminishes their ability to actively resist or attempt to evade arrest by flight as well. In Griffith versus Coburn, we see a kind of a typical series of events. Officers are called by Arthur Partey's mother. She wants to get him help at a hospital because of some impairment that he has. But The officers tell her, hey, look, we really can't do that because he is not currently presenting a danger to himself or danger to others. But they do note that he has an outstanding traffic warrant, and they offer to arrest him on the outstanding warrant and see if they can then get him some help. The mother agrees to this, and the officers go to the house. And then, you know, and this is typical in these cases, there's two distinct versions of events. According to the mom, Arthur is sitting watching television, and the officer, without provocation, goes in, jumps on him, grabs him around the neck, chokes and wrestles him for a period of time until Arthur goes limp. The officer tells a very different story. The officer's story is obviously what the officer's version of events is, but remember, the court on summary judgment and qualified immunity has to take plaintiff's version of events. The officer says that when he goes to take out his handcuffs to place Arthur Partey under arrest, that Partey charges him. There's an ongoing fight. At one point, Arthur Partey actually is able to undo at least one of the snaps on the officer's holster. And at some point, the officer puts Arthur into a lateral vascular neck restraint, carotid restraint, at which point, or at some point, Arthur goes limp. The court points out that there is a dispute of facts here, and disputes of facts generally have to go to a jury to decide. The court indicates, hey, look, this case rises and falls on which set of facts you believe. In other words, if you believe that the officer, without provocations, immediately jumped on top of Arthur Partey, while the second officer stood by and watched and began choking and wrestling him with no offer of resistance, then that would be an unreasonable use of force. If you believe the officer's version of events, then it would be a reasonable use of force. So the jury has to decide that. The court does point out, though, that the officer was trained on lateral vascular neck restraint, and the court uses this term. They say that the officer knew that that was on the high end of violence on the force continuum, or one of the more violent responses on the force continuum. Some words to that effect. Unusual choice of words, I think. Maybe a more significant force option would be a better way to put it. But the bottom line is the court did apply the Graham versus Conner test, and they said, hey, look, if in fact this happened the way that the mom said it had, then it was a minor offense. They were arresting him on a outstanding traffic warrant. He did not pose any physical threat before the force was used, because the mom said he was just sitting watching television when the officer suddenly, for no apparent reason, jumped him. And he wasn't actively resisting or attempting to evade arrest by flight at the time. The court does note that there is two versions of event, and it'll be up to the jury to decide which version to accept. Hey, a federal lawsuit from the Southern District of Ohio mentions lateral vascular neck restraint. So I want to point something out even before I get into the facts of Copen versus Noble County Sheriff's Office. There's a lot of cases that mention lateral vascular neck restraint, vascular neck restraint, carotid restraint. Remember that lateral vascular neck restraint is a registered trademark. It's a particular tactical system. I think sometimes that the courts don't necessarily realize that LVNR is this system, and if somebody uses that terminology in the case, they may use that terminology even though it is not really the registered trademark lateral vascular neck restraint. So again, it's something to keep in mind as you read these cases and as you look at these cases on this topic. At any rate, the Copen case involves a gentleman by the name of Copen. He gets into a argument with his live-in girlfriend. There is no allegation of domestic violence or domestic assault. He ends up deciding that he's going to pack up his things and leave their residence. So he's loading his Harley Davidson into a trailer, loading his firearms collection into his car. And his girlfriend, Miss Conner, for some reason, she decides to go to the sheriff's office It says in the case report that, in fact, she gives some kind of statement, although there's never anything in the case about an allegation of domestic violence. But she does ask members of the sheriff's office who are accompanied by the local police department to come out to the house and have a talk with Mr. Copen. When they get to the house, he's still, loading up his car and whatnot, and they have a chat with him. And Mr. Copen agrees that he will leave the residence and come back at a later time for the rest of his belongings. Obviously, the officers think that's what happens. They leave the scene. Mr. Copen doesn't actually leave the scene. He actually gets in his car and he actually drives onto a neighboring property that's being rented. There is a little bit of a dispute whether he's parked in an alley behind the house or whether he's on the rented property. Not really relevant to the use of force that's alleged in this case. At some point later, Mr. Copen goes back into the house and locks himself along with his two little Shih Tzus dogs in the den of the house. And he refuses to come out. That prompts Ms. Carter to call the sheriff's office, and the deputies and the local PD come back to the house. Really the main character in this case, and I say character, I don't mean that in any derogatory sense, but the one the plaintiff has the biggest problem with is Deputy Stokes. Now, what happens is they get out to the house and they're able to convince him to come out of the den where he's locked himself in, and they're able to have a chat with him. They get him outside and they're talking to him. And what is reported by the office is he starts to go crazy. He's swearing, he's screaming, he's making a lot of noise. There's neighboring houses. And to the point that the deputy calls the actual sheriff and says, hey, what should I do with this guy? And the sheriff says he's either got to leave or he's got to go to jail. That's what's going to happen. So at some point, according to the officer, he decides that he's going to take him to jail, and he tells him to put the dogs down. Mr. Copen is refusing, and at some point actually puts the dogs down and then lunges at one of the officers. Mr. Copen's story is totally different, as you can imagine. Mr. Copen says he's got his two little girls, how he refers to his Shih Tzus, under his arms, and he's outside when suddenly the officers start grabbing him by the arms and they're hurting the dogs, and he's telling them they're hurting the dogs, and at some point he drops the dogs, and he says that Stokes immediately puts him into, quote, a lateral vascular neck restraint. So in this case, it may be that the only one talking about lateral vascular neck restraint is actually the plaintiff. Hey, the Deputy Stokes says that actually how he goes to the ground is mostly under his own momentum when he lunges at this other officer. And once he's on the ground, Stokes says, yeah, I got on top of him, and I put my forearm into the back of his neck. So, in my mind, as I evaluate this and read the facts as reported by the court, I don't think there was a lateral vascular neck restraint here. But you have to remember that it's plaintiff's version of events, even though there seems to be a little of a mix in this particular case. Hey, the bottom line is the court looks at a number of different issues, and one of the things that comes up in this case, and believe it or not, we see this quite often in these cases, is Deputy Stokes says that the only use of force training he ever had was at the basic academy. He hadn't really read the agency's use of force policy or their statements about lateral vascular neck restraints in their policies, because the court actually outlines what the policy says on lateral vascular neck restraints. The court notes that it's a level 3. The resistance has to rise to level 3 before the officer can use the lateral vascular neck restraint. And again, the deputy says, he doesn't have any training on LVNR, and he doesn't even know what it is. So, part of that may be that true, because I'm not sure that putting your forearm on the back of the neck would be lateral vascular neck restraint. In fact, I know it would not be. So I think, there is a little bit of a disconnect in the facts of this case and what's going on. But at any rate, the court says that the basic academy use of force was sufficient so that the agency didn't have a failure to train claim, which is a little bit surprising. But they did find that Deputy Stokes because the acknowledgement that Mr. Copen was already on the ground, therefore did not have access to the firearms in the car, and Deputy Stokes had, at the very least, his forearm on the back of Mr. Copen's neck, that it wouldn't rise to the level of resistance necessarily to do the lateral vascular neck restraint, and therefore the case could go forward against Mr. Deputy Stokes being brought by Mr. Copen. So again, court found that based on the physical threat portion of Graham, that the physical threat no longer existed once he was prone and on the ground, kind of cuts to things like when somebody's already been restrained, as we've seen in other cases, and as we've seen up in the Minneapolis case, where it's alleged that, you know, that this officer Chauvin, you know, had his knee on the neck for 8 minutes, as we've all seen, after the handcuffing of Mr. Floyd. So again, we'll get to some bottom lines in a minute. But that's just another example case. Hey, we've covered a lot of ground in the last hour, so I just want to hit a few of the highlights. One, we have to recognize that there is some medical disagreement, even with respect to carotid restraints, the lateral vascular neck restraint, with respect to whether or not it can cause serious harm to an individual. I think law enforcement's got to take themselves out of that argument and get more focused on the cases, which we've tried to do. We've also looked at some policy issues, and we looked at, for example, Las Vegas Metro, who really got some accolades when they moved the lateral vascular neck restraint to an intermediate level use of force, where before they had it, particularly in the at the low pressure stages, to be a less significant use of force. I think we also have to look at the fact that the chokehold should only be used, in fact we should make it policy, that it should only be used in cases where deadly force would be justified. So the officer is left with no choice. The officer, if given the opportunity to take out their gun and use it, then by all means, then they should be able to do whatever is necessary to protect themselves or protect somebody else who's in danger of serious bodily harm or death, in an immediate danger. So, you know, really the focus of my summary now is really on lateral vascular neck restraint and carotid restraints, if you will, which is the blood flow issue, you know, slowing the blood down, going to the brain such that a person could be rendered unconscious for a short period of time in 4 to 7 seconds, and generally they are recovered in 5 to 20 seconds. I would note that as we're doing this video today, we're doing the filming of this video today, that President Trump signed an executive order banning the use of chokeholds except when deadly force is justified. Now, bear in mind that generally our federal mandates on local law enforcement are usually tied to the purse string. So in other words, the federal government can say, look, you can't use chokeholds, and if you decide that you're going to allow officers to use them, then we're not going to give you federal funding. That's generally how it works with some of these mandates. But again, the president, with the backing of some law enforcement people who we had at the session today, banned chokeholds except where deadly force is justified. And I don't think that's an unreasonable burden, because there is a danger with a chokehold of fracturing the hyoid bone, as we mentioned, of cutting off oxygen to a point that it can cause serious bodily harm or death. I think the jury is still out from the medical standpoint on LVNR and carotid restraint. So, and again, I think that's a debate we should stay out of. There is not a single case that says that carotid restraint or LVNR is absolutely deadly force. Courts have said it's a significant use of force. I think the Sixth Circuit case that we talked about said it's at the violent end of the force continuum, if you use a force continuum. Again, I didn't like that language, but that's what it says. And so I think, you know, from that perspective, we have to recognize that in law enforcement, that the courts are looking at it that way. So we have to make sure that officers are trained that this is not something that you can use unless there is a physical threat, an immediate physical threat that justifies it, and unless you've got a level of resistance that justifies it. Otherwise, and that we got a serious offense, so the 3 Graham factors. So again, I think from a training perspective, from a policy perspective, if you're going to have the lateral vascular neck restraint or the carotid restraint, then it's got to be put at the upper end of our force options, not to the level of deadly force, but at the upper end of our force options. And officers have to be trained not just on the skill, but on the when to use it and when it will be justified. I'd also mention that just because you don't have it in policy, just because you don't train it, doesn't mean that an officer is not going to do some tactic that may look like a neck restraint and that will be scrutinized as a neck restraint, whether it be an upper body control hold that devolves into a neck restraint because of the subject's resistance, or whether it's the officer's movement, whether the officer's trying to put somebody in a headlock to control their head so that they can gain compliance and get them restrained. The bottom line, officers have to use a degree of caution when using any kind of upper body control hold that could devolve into a neck restraint, because that will be highly scrutinized. Hey, I want to thank you for joining me, and have a great day, and please stay safe out there.